Good morning, everyone.
Good morning.
My name is Reuben Pope, and I'm a magistrate in Cleveland Housing Court. I've been a magistrate for about 15 years now, and I'm here this morning to help you understand what every landlord should know. This morning, we're going to talk about the landlord's duties and responsibilities, the tenant's duties and responsibilities, and believe it or not, tenants do have responsibilities. We're going to talk also about eviction procedures, and we're going to talk a little bit about screening tenants. I'm a firm believer that the more work you do up front, the more planning you do, the better off you're going to be and the better off your relationship with your tenants going to be. The first thing you got to ask yourself, do I really want to be a landlord? Being a landlord is hard work. It's a tough business, and it's getting tougher. It's not getting any easier because now banks aren't lending any money. You got to keep your property under repair. You just spent an hour and a half talking about the criminal actions that could be filed against you. So landlording is a tough business. I recognize that. And if you don't recognize it going in, then you're going to wind up in trouble. You're not running a charity. If the tenant comes to you, prospective tenant comes to you and says, I need a place to live, I'm getting put out of my place, and I don't have any money, just let me move into your place, run for the hills, all right? Or recognize that you don't have a problem, because that is not being a landlord, that's running a charity. On the board, you got a definition of a landlord. It's just a person that rents out property. That's the easy way to say it. It's a person that rents out property. And that's your job as a landlord. Here's some things thinking about up front that you can do to make your job a little bit easier and make your relationship with your tenant a little smoother. Rental applications. Some landlords use rental applications. I would say most landlords don't. But on a rental, if you do have a rental application, that gives you a chance to gather information about your prospective tenant. What their background is, what their financial situation is, where they're living now, how many times they've moved, the whole kit and caboodle. Whatever you want to ask them, you can ask them, because you're just asking questions to screen your tenant at this point in time. It's becoming a little bit easier in this age of the internet and the electronic age to do a background check. You can do a background check on a person. That's not an invasion of privacy, because everything that you're looking at is public record. Now, if you go beyond what's public record, then that may cause yourself some problems. It's very easy nowadays to do a felony check. You can go on the internet to the county website, punch the person's name in, and if they have any felonies, you can find that out. The other thing you have to be aware of is the sexual offenders. It's a problem when you rent to sexual offenders. So you have to be aware of that. You can check that information with the sheriff's office also. With our new computer system, you can even go online and check for prior evictions. As I talked about, the application, the reason why you want to have it, you want to gather information. The more information you have about the person, the better it is. You can ask them their name, their date of birth, their social security number, and their previous residence. You can ask them if they've been arrested for a felony. I'm not saying just because they've been arrested for a felony that they're necessarily a bad person, but certainly if they have been, you want to know the circumstances surrounding that. And I think it's very important to know if a person has been evicted before. It happens. People lose their jobs. People run into financial difficulty, and they may have fallen on hard times, but now they're back on their feet. So it's at least if you know they've been evicted before, you discuss it with them, and then maybe they can put your fears at rest. And Certainly, if they've been arrested for DUIs and disorderly conduct are not normally felonies. They're misdemeanors, and they're a little bit harder to find out about, but it may be a sign that they're going to be disruptive to your other tenants. Drugs are a no-no. Drugs could cause you problems with the police. Drugs could cause you personal problems, so certainly you want to know if a person has been ever arrested for a drug-related offense. All right, let's talk about landlord's duties and responsibilities. The landlord's main duty and responsibility is to keep the property in good repair and fit and livable. So if the tenant clogs up the toilet, if the tenant breaks a window, you got to repair it. It's that simple. You got to repair it. It's your responsibility. Does that mean you have to pay for it? You can charge the tenant back for those things that are done deliberately. If they have caused any damage to your property, that's no problem. You charge them back for it, but you are responsible because you're the owner of the property. You got to keep the property safe and sanitary. You got to provide garbage receptacles, keep the garbage off the ground, whatever. It's your property, your responsibility. You're renting it out, the tenant is living there, but it's still your responsibility. You can't transfer these responsibilities to the tenant. Some landlords put in their contracts, in their leases, that the tenant is responsible for cutting the grass. Well, you can put it in there, but if you come into court, we're not going to enforce it because that's your responsibility, right? The biggest thing we see with landlords, tenant's been living there 2 or 3 years, and the landlord wants the tenant to pay for having the carpet cleaned. Well, carpet cleaning is your responsibility. If you never have the carpet cleaned, we're not going to make the tenant clean it. That's the #1 responsibility for the landlord, and you got to keep your property clean. Of course, as a landlord, you got to keep the hallways, common areas clean also. All the fixtures in the house are your responsibility. Electrical, plumbing, heating. If the furnace breaks down, that's your responsibility. You got to get a repairman over there right away because no one can live in a house without heat. You got to do something to get them in there right away. This is where being a landlord becomes tough because if you got a furnace breakdown and it's going to be broken down for 2 or 3 days, you're on the hook. I mean, you might as well go get the tenant a room at the, you don't have to do it at the Marriott, but you better get them a room someplace at a hotel or something like that because you're on the hook. If you decide to supply appliances, stoves, refrigerators, then you got to keep those in good repair. If you don't have to supply appliances. There's no legal requirement to do so, but if you decide to do so, it's your responsibility. You got to keep them in good repair. So if the refrigerator breaks down, your responsibility, you got to fix it. This is very important. You got to keep running water to the premises. You got to keep running water to the premises. If the water bill falls behind and you get cut off, that's your responsibility. Tenant responsibilities. Tenant's #1 responsibility, of course, is to pay the rent on time. Landlords get in problems when the tenant doesn't pay the rent on time. You got responsibilities. You need that money. You're running a business. You need that money. Tenant, you make an agreement with the tenant to have the rent paid on the 1st of the month. Tenant says my pay dates have changed. You start collecting the rent on the 15th of the month. Pretty soon, you're collecting the rent on the 20th of the month. Guess what? You cannot now say the tenant didn't pay me my rent on the 1st, so I'm going to evict them. Once you start collecting the rent late, once you establish a pattern and practice of collecting the rent late, that becomes the agreement. It's as simple as that. That becomes the agreement. It's no longer due on the 1st, it's now due on whatever the latest date is that the tenant pays. The only way you can get out of that is you say, I've been accepting the rent late, I'm no longer going to do it. As of 1st of November, I want my rent on time. If you don't pay it on time, then you're going to be evicted. That's the only way you can do it, and you have to put it in writing. Of course, the tenant has a responsibility to keep the premises safe also and sanitary. They can't have garbage strewn all over the place. They got to dispose of the rubbish. You got to provide the receptacles. They got to throw it away. Plumbing is a problem. The tenants are responsible for not damaging the plumbing. That's the best way to put it. The tenant can't damage the plumbing, so if the kids throw stuff down the plumbing and you have to call the repairman out, they're responsible for that bill, but you have to pay it, but they have to reimburse you for it. Same thing with electrical fixtures. Like I talked about earlier, if the landlord supplies appliances, the landlord's responsible for keeping those appliances in good working order, but the tenant is renting your property. They can't just destroy your property. So if the refrigerator is not kept clean, they have a duty to do that. And you can put that in your lease, that they have to keep the premises clean and sanitary. And lastly, this becomes a problem at times because they gotta conduct themselves in a proper manner. They can't disturb the quiet enjoyment of the people around them. Loud parties, loud music, things of that nature are not permissible. Yes, ma'am.
Event that they do tear up your property, that you can go after their insurance, is that possible? Or is that something that you think should be required to cover yourself as a
I've heard of landlords doing that. I've never seen it come to court. I don't think there's a problem with it, except for the enforceability situation. Tenant loses their job, they're not going to be paying for renter's insurance. My thing is, if you agree with your tenant that they're going to have renter's insurance and that's part and parcel of your lease, and you put it in writing, I don't have a problem with that. But it may become an enforceability issue because if they stop paying, number one, you're not gonna know, and if something happens, if they stop paying, they're already responsible for you for the damages. So that, I don't see a problem with putting it in the lease, but it becomes like anything else. It's gonna be hard to enforce.
My understanding is that the landlord's insurance only protects the landlord and his property. So I always, in the lease, strongly suggest that the renter purchases their own renter's property. Mm-hmm. And because what happens is that something happens to the house, they're looking for you to reimburse them for what they lost.
Fire.
And I tell them, I can't do that, and my insurance company won't do that. You
Right.
got to have your own separate.
Right.
And if they don't do it, if you got it in the lease, they're just out.
You said you suggest that they have. You strongly suggest. She asked the question about can you require them? You don't require the tenant to have renter's insurance. You just strongly suggest that they, and you put it in the lease. Right. You put it right in the lease that you're strongly suggesting. I don't see anything wrong with that. Like I said, I've never seen it. I've heard of it. I think it's a good idea. I think it's a great idea. Like you said, if they don't do it, they're out of luck, but it's not going to protect you. I think that's the issue. Will it protect you? Here's another problem situation. Landlord has a right to come to the property, but you must be reasonable in exercising that right. The reverse of that is the tenant must be reasonable in allowing you to come to the property. Our rule of thumb is if the landlord wants to come and inspect the property, they've got to give the tenant 24 hours notice. If you give them 24 hours notice, especially, I would strongly suggest that it be in writing, because then it becomes your word against theirs. You just post a sign on the door, I'm going to be here at 11:15 tomorrow. That protects you on going to the property. Yes?
I have a Section 8 tenant, and basically Section 8 is coming in next week, Wednesday. Call her up to say that we need to come and check the unit out. And she says, I'm out of town, nobody's in the house, you cannot go in. And I don't care about a Section 8 inspection. That's her attitude. Now, I can't forcefully go into my own house, I suppose, or I can't.
The landlord has a right to enter his property with proper notice. Reasonable notice is defined as 24 hours. There's nothing in the law that says the tenant has to be there. There's nothing in the law that says the tenant can keep you out. In fact, the reverse is true. You have to let the landlord have reasonable access to the building. Yes, ma'am.
One more question to what he said. If there's an eviction in process and you're trying to figure out if they actually move because they don't tell you, and you put a 24-hour, does that, if there's an eviction in process, does that 24 hours still stand?
Yes. All right. But let's talk about that for a minute. If there's an eviction in process, and we're going to talk about evictions in a minute. If there's an eviction in process, be very, very, very careful about going in the premises, all right? Have somebody with you. Go with a camera. Go with a videotape. Call the police if you want to. Be very careful about that, because guaranteed that 52-inch TV that they had in their property is going to come up missing, all right? But we're going to talk about that in a few minutes. And if something breaks in your property, the tenant has a responsibility to tell you, because you can't fix it if you don't know about it. So if the water main breaks and the tenant doesn't tell you, you're responsible for the damage, but now they become responsible to you because they didn't tell you. So that's very important. That's the tenant's responsibility to you. They gotta tell you when something is wrong.
Sometimes if they fix some stuff in the house, this is the right or not, or they didn't tell me, or for some reason they fix some stuff, some plumbing or something, or they say I fixed that and I give you the bill, so I should pay the bill or what?
Okay. Let me repeat myself. The tenant has a responsibility to tell you what's wrong with the property. So if there's a leaky faucet and the tenant has their best friend come over and fix that leaky faucet, their responsibility is to tell you that there was a leaky faucet, so that you know that you can tell them, no, I'll have my man come over and fix the faucet, and he'll be there even faster than your friend will be there. So if the answer, I gave you a long answer to a short question, but to answer your question, no, you don't have to accept that. No, you don't have to accept that bill, because their responsibility is to tell you what's wrong with the property. Then you decide how you're going to fix your property. You don't want them deciding how to fix your property. How many have written leases? How many landlords have written leases? Nobody here has verbal leases? You didn't raise your hand on either one. I'm not putting you on the spot. Anybody have a verbal lease? Okay, let me tell you something. There's no requirement to have a written lease, all right? And some landlords I know wouldn't touch a written lease for all the tea in China. That's their choice. There's advantages and disadvantages to both. The advantage to a written lease is that you got the terms and conditions of your agreement in writing. The disadvantage to a written lease is you got the terms and conditions of your agreement in writing. All right? If you don't enforce those terms and conditions in that lease, then you might as well not put it in writing. Let me give you an example. Easy example I can think of. You got it written in your lease, no pets. Tenant brings a goldfish home one day. No problem. Goldfish is sitting in a bowl. He's swimming around. He's not bothering anybody. Next day, tenant brings home an aquarium with a lot of exotic fish in it. You don't say anything. Little tenant throws a rock or a baseball, shatters the aquarium all over your floor. All right? Now you come into court and say, I want to evict this tenant because I got a no pets clause. What am I going to say? You allowed it. You allowed the aquarium. They're pets. The fish are pets. You can't evict them. All right? And you got damage to your property. You got to call in carpet service and all of that. The whole 9 yards. Okay. So if you put it in your lease, enforce it. And don't make any exceptions. You're running a business, run it like a business. It's not being cold and hard-hearted. It's just being a business person. That's all it's doing. Oral leases, I think one reason why people like oral leases is it's easy, all right? My agreement with you is to give me my money. If you give me my money every month, we're gonna get along fine. If you don't give me my money, then we're not gonna get along. Another advantage to an oral lease or a month-to-month lease, I don't need a reason to evict you. I wake up in the morning, I wake up the day, and I say, I don't want to be a landlord anymore. But I don't have to tell you that. All I have to do is say, at the end of the month, not this month, it's got to be at least 30 days. Most people call it a 30-day notice, but it's really longer. At the end of the month, as of November 30th, I'm not accepting your rent. Come December 1st, you give them a 3-day notice. They say, what's this for? Well, I told you, as of November 30th, I wasn't accepting your rent. And that's all you need to know. You come into court, it's not a non-payment issue. It's a termination of tenancy issue. There's no defense to the action. There's virtually no defense to that action. Because you have the right to terminate the tenancy. You've given them reasonable notice, and unless you retaliated for something or you have caused some kind of housing discrimination problem, there's virtually no defense to that. So it becomes very easy to have your to end that relationship and go on with your life and let the tenant go on with theirs. Yes, sir.
If I have a troublemaking tenant and every month he or she comes up with another issue, you know, of course I allow it, you know, because of various things. Then one day I just get fed up with this individual, so I pull out my written agreement or a new piece of paper that just says, next month onwards, this current lease in which you have 6 more months left, the 12-month lease, you have 6 more months left, we're not going to go with it. It's now going to become a month-to-month lease. Is that allowed or that's not allowed?
No. Like I said, the advantage to a written lease is your agreements in writing. The disadvantage to a written lease is your agreements in writing. So you've agreed to keep them for a year. And you can't get, it's going to be difficult to get them out of there for that year. So if they don't like you or you all don't get along, you're stuck with them. Yeah, a couple more questions. Go ahead.
I have a tenant that's $2,500 behind in her rent.
No, you don't have a tenant anymore. You got charity case.
I mean, she was out of a job last year, but she started working in January, and she's still been late consistently. Last time she paid was August the 27th, and I approached So she still hasn't moved, and she still hasn't paid any rent.
You give her a 3-day notice.
But if she do give me money, can I accept that after I give her a 3-day notice?
Well, let's talk about that for a minute. The rule is this: you cannot accept future rents from the tenant.
This is from what she owes me in the
Exactly.
arrears.
All right. So you can take money on the arrearages. Your problem is this: you got a dual problem. You have accepted partial payments. I think I heard you say.
No, but I've accepted. She paid her rent, but it was like months that she would go without paying.
Okay.
Because she was unemployed.
Right.
But she has been working now since January.
Okay.
She's only paid 4 times.
But she always pays the whole amount of rent.
She gets paid the whole amount.
Okay. Okay. So what you need to do is you need to put her on notice that you're not accept this anymore. You have to pay your rent. Your rent's due on the 1st. If you don't pay me on the 1st of November, I'm gonna give you a 3-day notice and start the eviction process. Simple as that. Okay, if the landlord doesn't do what he's supposed to do, he or she is supposed to do, then the tenant has certain rights. And again, along with rights goes responsibilities. There's a problem with the property. The heat's not working right. The thermostat may be broken. The tenant calls you up and says, there's a problem with this property. I got a leaky faucet. The thermostat's not working correctly. I got a disabled ground in my electric plug. You have a responsibility to fix those things. The tenant has a responsibility to let you know what's wrong with your property. Tenant has to notify you in writing what the problem is. They have to notify you in writing what the problem is. If it's an emergency, no heat, no hot water, something of that nature, you have to fix it right away. If it's something less serious, the law says it must be fixed in a reasonable amount of time, not to exceed 30 days. So if you got a faulty ground, leaky faucet, bad thermostat, and you don't fix that, at the end of 30 days, once the tenant has given you that notice in writing, the tenant can deposit their rent with the court, with the clerk of courts, really, the clerk of courts. And once they do that, they're protected. They're protected. You cannot file an eviction against them, okay? I want to make that clear. They're protected. You can't file an eviction against them. There's some things you can do, but you can't file an eviction. The main provision is that they have to be current in their rent. So they can't, as the lady back there says, your tenant can't all of a sudden say there's something wrong with the property and begin depositing her rent because she's not current, right? In addition to depositing their rent with the court, they can ask for an order from the court to have the landlord fix the problem. So they deposit their rent with the court, they come in and they request that the landlord fix the problem. All right? That's called a motion to compel repairs. If it's something serious, no heat, no hot water, plumbing problem, they can also ask to have their rent reduced for that time period. And we will deal with it. Normally what will happen is we will set up a mediation between the landlord and the tenant after they deposited the rent and try to work it out. If you can't work it out in mediation, then it becomes more of a problem. And we may do any number of things. We may have an inspector go out to the property. We will We may have a trial on the matter. The landlord may come in and say, well, I've already fixed these problems, and the tenant will say, yeah, he fixed them, but it was 30 days, it was more than 30 days later. So if their agreement that it was fixed, then we might have to decide whether the tenant is entitled to a rent reduction. That's why it's important that you maintain your property and you do the things you're supposed to do. I said you can't file an eviction, but you can ask to have the funds released. And its basis is that the tenant didn't tell you, that you've already fixed the property, whatever. Okay. What happens when the tenant fails to fulfill their obligation? They turn in to the tenant from the shining. Evictions. There's several reasons why you can evict the person. The main reason is that the tenant has not fulfilled one of their obligations. Pay rent. That's the primary one. They don't pay rent, you serve them with a 3-day notice. Don't do it on the first of the month. Do it on the second or thereafter, because on the first day of the month, technically they have until midnight to pay the rent. So if they pay you rent for this is October, if they paid you rent for October, November 1st, they don't pay you rent, don't serve a 3-day notice on the 1st, but serve it on the 2nd, and you can evict them. Okay? You come into court, tenant didn't pay me rent, I served them with a 3-day notice, and 9 times out of 10, or actually 9.5 times out of 10, you're going to win that situation. It becomes more complicated if there's other reasons why you want the tenant out. Loud parties, sanitary conditions, they're not maintaining the garbage cans, they're not throwing their trash away. Then you have to serve a 30-day notice. And that's a true 30-day notice. If they violate one of the provisions that we talked about under 532105, then that's a true 30-day notice. By true, I mean it's 30 days. You can serve it today. It's 30 days. It doesn't go by the rental period. It goes by the date that you serve it. So you can serve it today on October 23rd, on November 23rd. If they haven't complied, then you can serve them with a 3-day notice. You got to serve the 3-day notice 3 days in advance. The reason why this picture of the 3-day notice is on the door, the law says that you got to serve the notice. It doesn't say that the tenant has to receive the notice. There are some court cases, however, that have said that the tenant must receive it. None of those have happened in northern Ohio. Most of those have happened in southern Ohio. But most of the time, landlords serve the notices by themselves. This just becomes additional evidence that you can show the court, hey, I posted the notice on his door, here's a picture of it. I did it on such and such a date. They weren't home, or they were home, they wouldn't open the door, so I just posted it on the door, and here's a picture of it being on the door. So that's why that slide is there like that. This is what the notice must contain. It must contain this language. We got a question earlier that you had to put something on the 3-day notice saying why you're evicting them. You don't. You have to put on there that you're being asked to leave the premises. If you do not leave, the eviction action may be initiated against you. If you are in doubt regarding your legal rights and your obligation as a tenant, it is recommended that you seek legal assistance. This language has to be conspicuous. What does conspicuous mean? It means to me, the first thing when I look at a piece of paper, that's gonna be the first thing I see. Your eye is gonna go right to that notice. So you can put it in big letters, you can highlight it, you can arguably, as long as it's conspicuous, as long as, and it's on that notice that you are asking them to leave 3 days from now, then it will be probably be a good notice. We have some that they sell at Ohio Legal Blank, and this is not a commercial, just information purposes only. They have a landlord tenant kit, and in there is a proper 3-day notice. I've seen some come a notice to quit from Office Max or some other places. They are not there because it does not have this language on it. They are not valid because it does not have this language on it. So be careful. If you go to an office supply place and they have a notice to quit, but the notice to quit does not have this language on it, that's not a valid 3-day notice. All right? Yes, sir.
At the end of the 30 days, it expires. Tenant fails to perform on the 1st of the next month. They are out of their lease, they're out of their contractual obligations. Do I still have to go through an eviction, or, I mean, technically there's no lease holding them there?
Yes, you have to go through an eviction. That is the only way you can get a person off your property. All right? The last time I did this, I think a person asked me that question 10 different ways, and my answer was 10 times 10. Do not get involved in a self-help eviction. It's as simple as that. You don't want to do that. That's the last thing in the world you want to do. I've done one self-help eviction. Lady had junk in her apartment. I can say that now because the case is over. It was junk. I mean, I think I gave her maybe $500 for her possessions. I gave her $5,000 for the attorney fees. So she went out and hired an attorney, and then when you're involved in a self-help eviction, you're responsible to the tenant for any damages that they suffer. So you do not want to get involved in a self-help eviction. Come to court, cost you, what is it now, $115, whatever. But that's better than $5,000. Yes, sir.
When you're in a group home or boarding home, same procedures, I'm assuming. If I got 5 people, a
group home, that's not a landlord-tenant situation.
How about a boarding home or a halfway home? You know,
halfway house is not a landlord-tenant situation. It's not covered by 1923-01 or 02. I don't have that with me, unfortunately, today, but I would say that those two are not landlord-tenant situations. An eviction case is just like any other lawsuit. People forget that. It's just like any other lawsuit. You got to prove your case by a preponderance of the evidence. It's not a criminal matter. It's not beyond a reasonable doubt. Preponderance of the evidence means you got to convince me that it's more likely than not that you're telling the truth, that these are the facts. So 51% to 49. 51 to 49, you win. How do you do that? Testimony. You can testify yourself. I went over there, I served a 3-day notice. I keep my rental records. They haven't paid me for the last 2 months. Or you can have a witness come in with you. When I went over there to serve the 3-day notice, my brother was with me, my wife was with me, John Doe was with me, and he watched me put it on there. They weren't home. He can testify to the fact that I did that. Records, receipts. You're a landlord, you're in business, you have to have records and receipts because you have to tell the IRS that you're making money or you're not making money or whatever. Bring your records with you. Bring your receipt book with you. Landlords don't bring receipt books to court anymore. I don't know why they stopped. Tenant says, I paid him in cash. I paid him in cash. I pay him in cash every month. He never gives me a receipt. Never, ever gives me a receipt. You're standing there dumbfounded. You can't believe that somebody would stand in a court of law and tell a lie under oath. All right? You can't believe it. All right? You better hope I don't believe it, because you're going to be out of luck. So bring a receipt book. If somebody hands you cash, give them a receipt. The Cleveland ordinance requires you to do it. The state law doesn't require you to do it. Common sense requires you to do it. Give them a receipt every month if they're giving you cash. Give them a receipt if you have a check. Most of the receipt books I've seen say, this is what you owe, this is what you paid, this is your balance. $0, $200, whatever. So give them a receipt. You come into court, you show that receipt book, you show a consistent pattern of giving receipts every month, I'm going to believe you. Anybody would believe you, all right? Credibility as a witness. It enhances your credibility. The one disadvantage the landlord has when they come into court, the tenant doesn't have to tell you in advance what their defense is. An eviction is an extraordinary procedure, extraordinary action under the law. They don't have to tell you what their defense is. So they don't have to tell you that before you come to court that they're going to say that they paid the rent. They don't have to tell you that before you come to court that they're going to say you don't maintain your property. You're going to be standing there, you're going to hear it for the first time when you're in court, more than likely. So you got to be on your guard. You got to be able to put your best foot forward. Very quickly, I'm going to go over security deposits. Most of you know that if you take a security deposit, you have to give it back. It's just that, a deposit. The thing about it is, if it's a security deposit, you can deposit. If the tenant owes you money, you can deduct from that deposit any money that they owe you. So if they owe you for back rent, they owe you for property damages, you send them a letter saying you gave me $750 for a security deposit. I'm deducting $750 for rent. I'm deducting another $750 for the damages you caused to my property. If you collect more than the monthly rent, then you may be liable to the tenant for interest. If you hold that money for more than 6 months, then you may have to pay interest. You want me to say you are going to have to pay?
Well, where do you get the percentage? I mean, how do you decide?
Okay, the percentage is 5%. Okay, some people used to collect 2 months' rent as security. I haven't seen that in a long time. So whatever, if you got $1,000 for rent and you collect $2,000 as a security deposit, you got to pay them 5% of that extra $1,000 that you have if you hold their money over 6 months. Okay? A little complicated, so best rule is just take 1 month security deposit. Like I said, when you terminate the tenancy, you send the money back to them. If you don't send the money back to them, any monies that you wrongfully withhold, you requested $750 security deposit, the rent is $375, and you don't send them the whole $750 back, you could be liable to them for the amount that you wrongfully withhold. It has to be wrongfully. That's why you provide the written notice I talked about, the itemization. This is why it doesn't absolve you from your liability, but it certainly would help. And you're responsible for returning that security deposit within 30 days after the tenant leaves. You have up to 30 days to return it. They've got to provide you, there's other rules and regulations, they got to provide you with a valid address. If they don't provide you with a valid address, you can't send a letter out, you can't send the money back. If the landlord doesn't return the security deposit, the tenant may be entitled to twice the amount that was given as a security deposit plus attorney fees. If the tenant doesn't give a forwarding address, they're disqualified from receiving the double damages. The key words here are wrongfully withheld. So if the landlord wrongfully withholds money from the tenant's security deposit, they may be liable to the tenant for double damages, as I mentioned, and reasonable attorney fees. And I can assure you the attorney fees will be a lot more than the monies owed on the security deposit. There are two cases out there which explain what wrongfully withheld mean. One is Vardaman and Llewellyn, the other one is Smith versus Paget. In Vardaman, the court held that wrongfully withheld includes only the amount owing in excess of the deduction that the landlord could have taken. Okay, that's a mouthful. What it means is that if you are entitled to part of the money, that part of the money is not subject to double damages. Only the amount that was wrongfully withheld. So if you charge a tenant for damages, if you say the tenant owes you 1 month's rent and the tenant really only owes a half a month's rent, then you're going to pay twice the half month's rent that was due. Smith versus Paget says that even if you send out the letter that itemizes what is being deducted from the security deposit, then the tenant can still recover the double damages and reasonable attorney fees. So the letter does not exempt you from wrongfully withholding. If you wrongfully withhold, then you will be charged double damages. Okay, let's go over quickly what terms are barred from leases. Number one, the landlord has certain duties that were enunciated previously under Ohio Revised Code 5321.04. We talked about that earlier this morning. You can't put in the lease anything that modifies those duties. So you can't say that the tenant is responsible for snow plowing, although a lot of landlords do. You can't say the tenant is responsible for maintaining the grounds because those duties are assigned to the landlord under 5321.04. Warrant of attorney means that you can't say to the tenant they have to pay for your attorney if it is contrary to the statute. There's no agreement to pay attorney's fees. There's no exculpatory clause cannot be in there. That means that you can't transfer any of your duties to the tenant. And the big item here is that there's no unconscionable agreements. You can't force the tenant to live in squalid conditions. You can't force the tenant to pay you $75 a day for late fees. That would be considered an unconscionable agreement. And lastly, but certainly not least, you can't engage in a self-help eviction. All evictions must be handled through the court. All evictions must be handled through a legal proceeding. Typical problems that landlords run into when you rent to someone doesn't mean that that's the only person that is going to be living in your house. You have to be very careful about who you're renting to. You have to be very careful about enunciating it, that there's a limit on the number of people that will be living in the house, and otherwise you might be in for a surprise when the rest of the family moves in. Destructive tenants, of course everyone knows about the destructive tenant. The non-paying tenant, the most common problem that the landlord faces, and of course injuries. If a tenant gets hurt on your property, you may wind up being liable for it, depending on the circumstances and what the allegations are. And lastly but not leastly, in this day and age, if a tenant abandons your property, you have to be careful about that because typically we see it all the time. Landlords, the tenant moves out, the landlord's not there, and the tenant leaves the keys behind or doesn't leave the keys behind, leaves the door open, vandals come in and destroy the property. The landlord wants to charge the tenant for it. It may or may not be their fault, but the way you protect yourself there is if you set up a time for the tenant to meet you at the property, do an inspection, get your keys, secure the property, and then you're good to go. As I said, the rest of the family moves in. You think you're renting to one or two people, a mother and a child, then the boyfriend, the sisters, the brothers, and everybody else moves in. You can see everybody knows about the destructive tenant and what can happen if a tenant doesn't take care of your property. And the tenant has a duty to take care of your property. You can't shift the burden to repair the property, but you certainly can bill the tenant for any destruction that they cause. The non-paying tenant, all landlords know about the non-paying tenant. That's why I'm employed now, because of people don't like to pay their rent. And as I mentioned, the tenant who gets hurt on your property could be a problem also, as is the tenant who abandons the property. We're finished with the presentation at this point in time. If you have any questions for me, feel free to ask them. I will remain around to answer any questions, and I thank you very much for coming out this morning. It's always a pleasure to do these presentations and meet and greet and talk to landlords.